Okay, this is the webinar. Good afternoon, everyone.
Jonathan, wait 1 sec.
Are we not started?
Give me 1 sec. Okay, Jonathan, you can start.
Thank you, Rabbi. Good afternoon, everyone. Thank you for joining us on this webinar, interview, discussion, panel, talk. I'm joined. My name is Jonathan Hoffman. I am an advocate at the Johannesburg Bar. I'm honored to be joined by Rabbi Marcus Solomon, who has recently been appointed as a judge of the Supreme Court of Western Australia. It's an absolute honor to have you. And good evening. Thank you for joining us so late. I know it's 9 p.m. in Australia. Rabbi, Judge, what should I call you? Rabbi, Judge, Justice? What is your preferred title?
Well, thanks, John. First of all, it's a pleasure to be here. And being 9 o'clock on a Sunday night, I'm at home. And the one thing I can assure you is that whatever you call me of any of those titles will be more respectful than what I'll be called if I walk back into the kitchen.
Yeah, well, please thank your family and thank your wife for letting us take you away from them at this late hour. We so appreciate it.
No problem.
It's always a funny thing in South Africa. We have to call our judges in court, my lord, in the High Court, or your worship in the Magistrates Court. And you know, there's a part of me that always has a bit of a discomfort having to sort of title someone with that, something that is usually reserved for a religious aspect. But in Australia, you're called Justice in court, Your Honor.
In court, Your Honor, and in justice, but in direct conversation, it would just be judge. So judge. That's the convention in Australia.
So none of my lord or your worship.
We don't have lords and worships, not in the Supreme Court, no.
But first of all, a big mazal tov on your appointment.
Thank you.
They say in our profession, you really only have 3 promotions. The first is when you get your red bag, when you've done a good job as a junior advocate. The next is when you take silk, and the third is when you get elevated to the bench. So you become a judge, and you've achieved all 3. So it's a tremendous achievement, and mazal tov. It's absolutely amazing.
Thank you. The red bag one would be a mystery to non-lawyers, I suspect, but it is the same convention.
In Australia, it's quite antiquated. I know that
it is.
In England, they've got this, and you'll know, and lawyers won't know. They've got this little quaint shop in Chancery Lane called Eid of Ravenscroft, which dates back to the 1600s. And barristers in England, when they get their red bag, there has to be a procedure. You have to get given it by a silk, and it's a very prestigious event. And
it's a similar, with little less formal, but similar here. But it's only within the confines of a small proportion of the legal profession who are advocates. Outside that forum, if you tell someone you were given a red bag, they'll assume that you've been engaged to sit in a shopping center with Santa Claus, I think. So it's a peculiar thing.
But it is those little peculiar things that make the profession interesting. The pouch on the back of a junior counsel's robe that traditionally money would be put in if you were doing a good job, the red bag. And it's one thing I wanted to touch on, which I'll get to later, is that the profession has evolved and the laws have evolved, but we still have these quaint idiosyncratic tendencies that we keep. But starting off with your journey, and just to let everyone know, you first completed your smicha, you became a rabbi, you studied at 770 and in Australia. Then you went on to become a teacher back in Australia, in Perth. You studied law, you became a solicitor in the 90s and a barrister in the 2000s, a silk in the 2010s and a judge in the 2020s. So the journey is, Is that an accurate summary of a précis of your background?
That is a summary that reflects a great capacity to write succinct submissions.
I will present my heads of arguments after the lecture, and we can mark them. Each of these iterations of Marcus Solomon, was it a reinvention of yourself, or would you call it an evolution of yourself?
They're certainly not reinventions, because those iterations or stages were not mutually exclusive, in the sense that I've never ceased to regard myself as primarily, in many respects, a rabbi and a teacher, particularly a teacher. So I have never seen my role as a teacher of Torah, of Judaism, as ever having stopped. And really that remains today my principal passion, whether in a formal sense, because I teach, I give shiurim, and particularly on a Sunday. I've just finished my normal, I do about 3 or 4 hours teaching kids, Talmud, Mishnah, Chumash, and I give various other shiurim. And I regard myself, that is my most important thing that I do. That really energizes me. That's the part of the week I look forward to the most, and the part of the week that's most meaningful work. I think that if a Jew conducts that, in itself makes the person an educator in spreading the message of Judaism, the ethics and the menschlichkeit of Judaism to the broader community.
I suppose they aren't really mutually exclusive disciplines. You know, when you're a teacher, I suppose there's a lot of conflict resolution amongst students.
There's a lot of conflict resolution, and there's a lot of acting common to both teaching and advocacy. But also in the teaching of Torah and Judaism, and I mean, both is about Judaism more broadly, not just teaching, but representing people's interests, ensuring that people's interests are justly addressed. And one does that as a rabbi, and obviously in a more pastoral fashion as a rabbi. But that, at the end of the day, is also one of the objects of the justice system.
I know certainly that when I've studied Torah and when I've done learning with a rabbi, you're engaged in a very similar critical thinking or discipline of critical thinking that one would have to do in advocacy, and so that they kind of teach you to behave in the same way, and they're very complementary to one another in that regard, at least.
The academic skills are very, very similar. So when you, I mean, going from yeshiva to law school was a cultural shift, but in some senses, from an academic skill perspective, was not actually a great shift. And I mentioned to someone else in an interview I did that when I looked back and cleaned up a lot of my documents moving out of chambers, because I was at law school shortly after I'd had some years in yeshiva, my first couple of years in law school, most of my notes were in Aramaic, were in Gemara terms, because the terms were so similar. It was much easier for me to record the concepts and the notes in Gemara Loshen, as we call it, in the language of the Talmud. So my notes from my first couple of years in university are peppered with Hebrew and Talmudic expressions in order to assist me to get down the ideas quickly and clearly.
So I take it your classmate, you weren't very popular with your classmates. There wasn't any note sharing.
Well, yeah, probably not. But actually, there is a good story about that. If I could just indulge, I didn't spend a lot of time at university because I was teaching full time and I was studying law. So I would run, and there was no online learning in those days. So I would rush to university in between classes and then rush back to the Jewish school to teach, which meant that I really didn't participate in university life. And because I was very engaged in Jewish community life. And that was fine, except that it had one very difficult consequence for me. At the end of my first year, I did my first, I had a criminal law exam. And you had to pick, you were given 5 questions and you had to pick 4 out of the 5. And I was quite nervous, end of my first year of law, and I read the first question and I could not work out what the question was about, because it was about a student who went to university and spent all day at a place called Steve's. Now, Steve's was the tavern that every single university student frequented. But I had no idea because I wasn't part of university life. To anyone else in the year, it was clearly a question about intoxication and its impact on criminal culpability. But I had absolutely no idea what the question was about. So that was some disadvantage, but otherwise it was fine.
Well, you seem to have made it through sufficiently that...
yeah, I got through. I picked the other 4. Fine.
Yeah. One thing when I'm studying that I have a difficulty with in my approach to studying is, when as a lawyer, we're told to deductively reason, ask critical analysis, get an answer for everything. But, in Torah, we have, for example, mishpatim and chukim. To anyone watching who doesn't understand them, mishpatim is a mitzvah we understand. It's logical, we understand it. It makes sense why it is a mitzvah. And then the chukim are those things that we don't understand. They're mitzvahs because God says they're a mitzvah, and we must accept them. The lawyer in me says that's not good enough. I can't accept it at face value. And it's a great difficulty for me when I'm told, listen, you just have to accept it at face value. How do you, as a lawyer and as a rabbi, reconcile those two diametrically opposed concepts?
Well, John, you and I need to learn a little bit more Chumash, I think, because this is an issue discussed by the great medieval commentator Nachmanides, the Ramban, on the last few parshas in the Torah. And that is the question of whether all mitzvahs have a logical reason. It's just that we sometimes struggle to grasp the reason, or whether mitzvahs don't have a reason and we're simply commanded to do them and ought not to spend too much time pondering what the reason is. Nachmanides and Maimonides are firmly of the view that all mitzvot ultimately have a reason. We have to have the humility to appreciate that there are some of those mitzvot whose reason is for the time being beyond our grasp. But that doesn't mean that we shouldn't try and relate to the mitzvot from an intellectual perspective. And in fact, the Ramban then goes on in relation to some of those mitzvahs that don't have an apparent reason to suggest reasons, and they may or may not be the ultimate reason. But the Ramban, Nachmanides and Maimonides were both great rationalists, and therefore would encourage you, John, and all of us to relate to the Torah also as a great fountain of logic and rationality. And if we can't relate to it logically or intellectually, then the response to that must be we have to have the humility to realize we've got more work to do to try and appreciate the wisdom behind the mitzvah. So I think for some, you can be content to say, well, God commanded me to do it. Doesn't matter that I don't understand it. And that's one level of religious service and commitment, and that's wonderful. But if you're struggling with it, you're in good company, because you're in the company of some of the greatest rabbis of Jewish history. So don't feel bad. Just we just need to have the humility to realize we've got more work to do.
And I suppose humility and law are also not a terribly,
natural fit.
Natural fit. I was about to say.
It's interesting because that's the impression that the general population have, that lawyers are aggressive and arrogant. But in fact, in Jewish law, first of all, the whole place of lawyers in Jewish law is a separate, that's a whole discussion in itself. But in terms of the judge, Maimonides writes quite strongly in his codification of the laws of judges and the judicial system that humility needs to be at the forefront of every judge's mind. And in fact, the Rambam writes this quite picturesquely. He says that the judge has to imagine a sword hanging above the head. And if they don't have the proper humility and commitment and dedication to getting the right answer, the sword will fall. And the Rambam, Maimonides, uses the laws about judges generally to talk about the importance of people who exercise executive and public power, understanding the humility and empathy that they must have towards the people whose lives they affect. And so from a Jewish perspective, although in the broader community people don't necessarily associate lawyers with humility, from a Jewish perspective, humility has to ground every judge in the work that they do.
And I think that humility is important from the perspective, and you were speaking about in the previous interview about the counter side of humility being empathy, that a judge must be empathetic to the people who are before them and understand the human experience and the things that people are going through. And certainly as an advocate, as a barrister, that's also a great struggle that certainly in a commercial sense that I deal with, is very often you are asked to act for clients who are legally correct, but from an equities perspective they don't talk to each other. The equities are in the favor of the other party, but the law is in your favor. And empathy would dictate you to almost not act in your client's best interest, but the law says you have to act in the best interest of your client. We've got a cab rank rule. Somebody comes and first come, first serve. How did you deal with this in your profession, Matt? That sometimes...
Well, like most lawyers, I claimed only to have acted for saints. But in seriousness, that's a tension in any legal system, and it's a tension in the Jewish legal system. The Talmud has discussions about this, where certain rabbis of the Talmud talk about and relate the dilemma they face in advising people or deciding matters of law that won't produce an equitable outcome. And so any system of law faces that tension and that dilemma. And so it's not as if this is a principle that is somehow foreign to religious law within Judaism. It is an inherent part of any system of law. And you have to deal with that as best you can. At the end of the day, both in Jewish law and in secular law, the law prevails. And one can't permit an individual's difficult circumstances to distort or pervert the law. there's a piece of passage of Talmud which talks about, I think it's David HaMelech, who would rule in accordance with the law, and if it meant that a poor person went hungry, he would ensure that that person was compensated from the public coffers. So that tension is reflected in that story. And of course, the Talmud also talks about the tension that exists between the application of law and the reaching of some form of compromise. The idea of tzedek that has with it shalom, because sometimes pure din, or the application of law, doesn't produce a peaceful outcome, whereas compromise can produce a level of shalom, as the Talmud calls it, and that is ultimately more important than din, than pure law. So these concepts of the tension that exists between law and equity, fairness, and the pure application of strict law apply in all legal systems, and certainly Judaism grapples with that in a very deep way in the Talmud. So these are not foreign concepts to the rabbi.
Well, I know certainly that when you refer a dispute to the Beis Din in South Africa, you go through a preliminary mediation process to see if you can reach resolution. And if you can't, which is not binding, and if you can't reach a resolution, which they urge the mediation process to continue, only then do you proceed to a din Torah.
Yeah, but Jewish law actually has something beyond that, and I don't know whether the Beis Din in Johannesburg does this, but traditionally there's a concept in Jewish law that is foreign to secular law, and I've spoken about this a few times, and that is a judicial compromise. So that when the case starts, the court indeed urges the parties to empower the court to apply not law, but what the judges consider to be a fair compromise. So it's a judicially imposed compromise rather than the parties' compromise. And that reflects Judaism's focus on and preference for reconciliation rather than the strict application of law. That concept does not exist in non-Jewish law.
It doesn't, but I'm sure you've been in a situation during your practice as a barrister where a trial or a matter is about to begin and both sets of counsel get called into the judge's chambers, and the judge looks at both parties and says, this thing really has to settle. You can never say it officially in court, but he strongly encourages the matter to settle because he can see that it's in the interest of both parties. I'm not sure if you ever experienced that in your profession or when you're in practice.
Well, I've certainly experienced the judicial growl about the necessity for the parties to be reasonable and seek a compromise. But Jewish law goes further and
even further,
and really requires the court to urge the parties to empower the court to impose a compromise. So that's a different.
Do you think there's a room for that in secular law? Do you think secular law can be developed to incorporate some kind of
that would take a
judicial compromise?
Because in secular law, there's a very bright line between, a very clear dividing line between mediation and compromise on the one hand, and the deliberation and decision in accordance with law on the other. And of course, once one embarks in secular law, once one embarks upon the path of compromise, the judge is disqualified from ever being the judge. And that may, some people take the view that is also the case in Jewish law, but is certainly in secular law, there's a very clear dividing line. And it would take a very significant shift, I think, in legal culture for that.
Going on a bit of a segue and going back to your recent appointment as a judge. As I was explaining to you shortly before the webinar, when we spoke telephonically, we recently had a series of interviews for appointments to the bench in South Africa, and there were a few Jewish candidates, one of which was going to the Apex Court of South Africa, the Constitutional Court, another which to the local division in Durban, all interviewing to those positions. And their faith, their Judaism came up quite strongly. Well, one was, a lot of it was political, but the one question that was asked was, well, will your faith get in your way of being a judge? Well, let's say you have to act on do you keep the Sabbath? Because if you do, it's going to be a big problem to your appointment. Was this even a consideration in your interview process with the Attorney General? And should it be a consideration?
Well, I mean, I think judicial appointments happen a little differently here. There isn't generally a formal interview process. It's quite a mystery the way judicial appointments, I think, in many countries, including Australia. It's not an open, transparent system, but it's well known that the government of the day, through the Attorney General, consults with the Chief Justice and the court about upcoming appointments and consider who would be the most suitable person and then approach that person, rather than having a formal application and interview process as you would for other jobs. In terms of one's faith, I have to say, never experienced anything other than the greatest respect for my religious faith. In terms of Shabbat observance, the court sits Monday to Friday. There is a facility for a duty judge, that is an after-hours judge, and everyone, there's really a roster for duty judge, but as soon as before I got to the court, the Chief Justice, who's an absolutely wonderful person, and a number of other judges, fell over themselves to let me know that they would cover my Shabbos for me, because they have great respect for commitment, and obviously I will offer to cover Sunday or Christmas or whatever it is for them, but there's been enormous generosity in wanting the court to have that diversity. And South Africa is a model of diversity in many respects for the late 20th century. And therefore, I would have thought any court in the Western world today would wish to reflect a diversity of human experience, and both in terms of gender, race, creed, and if that means that some adjustment is made to rosters in an equitable way to permit someone to observe a religious commitment, then in today's day and age, one would expect that to happen. And certainly in relation to my appointment, it's hasn't been a problem at all.
And I suppose
I only started a few weeks ago, and I said to the Chief Justice, you need to know that in September, he said, well, what's the big deal? Other judges have commitments that arise for different matters. You just don't sit on those days. So I haven't encountered any difficulty, on the contrary.
And you mentioned the diversity, because as much as judges are objective and they apply the law, they bring their human experience into it. And the more diverse the judges that sit on the bench, the more human experience and that rich tapestry of life you bring to the bench, which is reflective of society. And I agree. I think it's absolutely important. And
it was the ABC interviewed someone from the Jewish community here about my appointment, and they said to them, isn't it remarkable that an Orthodox rabbi should be appointed to the Supreme Court? And this person, who has a lot of experience and a bit of chutzpah, said, I don't think it's remarkable at all. Our justice, the foundations of our justice system are based on the Bible, and Jesus himself was an Orthodox Jew. What's so remarkable about it? He was a bit tongue-in-cheek, but there's also an element of
No,
truth
100%.
in that. Yeah.
And we know
So-
that. Sorry, I interrupted
No,
you.
I don't. I mean, a lot of people have asked me this question. I don't perceive any conflict at all. The common law system is a just system of law that reflects the vision that the Bible has for humanity of a just and moral society. And so there may be very marginal and rare instances where I or other judges would recuse oneself, but in a broad sense, there is no. The two are entirely complementary.
And we obviously, there's a halachic, I guess you'd call it a maxim of dina de malkuta dina, that a Jew will respect the law of the land in which he lives. So although halakha will teach you, will say one thing, one upholds the civil law of the country in which one lives. So it isn't something that should conflict with one's faith. But I can imagine notionally in practice that you may have been presented with an issue where civil law conflicted with halakha. Was that ever an issue?
Well, I mean, nearly all my matters were commercial matters, building and construction, trade, corporate company, contract disputes. So it really did not arise in that context. I mean, there is theoretically, which is not even on the table in Australia, but if you had laws that prohibited kosher slaughtering or, God forbid, circumcision, things of that, obviously those would produce some difficulty, but they are not on the horizon and would be very rare in any event. Well,
the one thing I was just thinking of while I was preparing for the interview was assisted dying. That is, as I understand it, legal in Western Australia, subject to strict regulation, obviously, but that would, in my mind, conflict with pekuach nefesh, and that is that's a quagmire of a situation where I certainly wouldn't know how to resolve it if I was in your position.
Well, I mean, I have spoken to there are retired, I'll just keep to the retired judges so that I'm not speaking about any present judges, but I do know, for example, retired Catholic judges who have said to me that if such a matter had come before them, they would have to recuse themselves. And again, they would be rare and few and far between. But if that were to present a problem, I doubt very much that I would be the only one for whom that would present a problem.
And one would have to deal with it.
Yes.
At the appropriate stage. But certainly, we have this provision in our constitution, our South African constitution, that a judge must apply the law impartially without fear, favor, or prejudice. And I'm sure there's a very similar principle. And that's our duty as legal practitioners.
Well, that one takes an oath as a judge to do that. Yeah.
And certainly I understand that. And the lawyers and barristers and solicitors appearing before you understand that. But a lay person who comes before you may see a rabbi wearing a kippah with a long beard, and there's a perception of a person and of a bias, whether conscious or unconscious. How does one put the lay person's mind to rest as to one's objectivity and impartiality? Is that something that you've experienced in your appointment so far?
I haven't experienced it in my appointment, and I never experienced it in practice. The law here is a law that is a just law legislated by Parliament or part of the common law, and there's never been any suggestion that I do anything other than apply it to the best of my ability. So I don't foresee a situation where someone would imagine that my faith would lead me to a conclusion that was somehow inconsistent with the law. It just, I can't imagine how that could, I mean, there are always people who have irrational views, and they, I mean, there are people who make irrational assertions about judges every day in courts all over the world, and you just have to deal with them. But in terms of a rational and sensible objection, it's very difficult to imagine how that could possibly arise.
And one would imagine that any solicitor or barrister appearing for such person would talk sense into that lay person.
Well, if they're competent, yes.
Let's just building on that theme. You know, we had an absolutely awful system of apartheid in South Africa. Australia had an awful system of the way that Native Australian peoples were treated, which gave rise to the stolen generation, which is well documented. And a lot of those judges who sat on the bench during those periods where these laws were manifestly unjust and conflicted with every fiber of humanity, they themselves said, well, we apply the law impartially without fear favor. Luckily our law isn't there. This is more a hypothetical question. Luckily we have evolved beyond that as a society and as people. But in that situation, and hindsight is 2020, can you imagine that a person in your position's job would be, well, we work within the confines of the law as we have it, and we try change the law from within, or rather, I would not be a judge in that system?
I mean,
no easy questions.
Well, that's not a question that can be answered in generality. That's a question that has to be answered in respect of the particular predicament that one encounters. It's very easy to be righteous about previous generations who were operating within a system that they regarded as normative, and which was normative in the society in which they grew up. And so in my parents' and grandparents' generation, and even when I was much younger, the way people treated marginalised elements within society, whether it be Indigenous people, whether it be gay people, all sorts of marginalised people were treated in a way that was appalling, but people didn't appreciate how appalling it was. And so one needs to be careful, I think, about being enlightened retrospectively and critical of previous generations. I mean, in terms of Aboriginal people, I actually, at one stage of my career, did a lot of work with Aboriginal people. I spent about 2 years working with some Aboriginal tribes in an area called the Pilbara, which is in the northwest of Western Australia, in relation to their land rights and their negotiations with some multinational resource companies. And I can tell you, for a Jewish audience, I mean, I have so many stories that arose from those 2 years. And I learned a lot from them about connection to land, connection to one's soul. And I can tell you, the first day I got there to work with these particular tribes, I was ushered into a room which was full of the elders of the tribe. It was a small room with many, many men and women in it. It was 47 degrees Celsius, no air conditioning. It was quite an oppressive environment. And for them, there was a succession of what they call white fellow lawyers. And they started a very bitter argument between them, and I lost complete control of the meeting. I was supposed to be advising them on something very significant, and I might as well have not been there. I lost complete control. And then somehow I had an inspiration, and I sort of banged the table, and I said to them, you might think I'm just another white fellow lawyer, but actually I come from a tribe. I also have a tribe, and I'm an elder in my tribe. And let me tell you something about my tribe. My tribe lost their land. And every time they fought each other and fought within themselves, they lost their land. The only way you're going to learn to get back your land, like my tribe did, is to get on with each other. And I managed to get silence in that room, and I think I won their respect. And from that point on, I became quite close to them because they regarded me as a tribal man. The truth of the matter is, though, that I learned much more from them than they learned from me about many, many things. And that was quite an important part of my experience as a lawyer, I have to say.
But I think it goes back to what you were saying about faith creating empathy. You were probably able to connect with them and interact with them because of your training as a rabbi and your ability to empathize with.
Yeah, I think they recognize. Yeah, I don't actually think it was the rabbi thing. I mean, that was helpful, but I actually think it was just part of being Jewish, actually, and being able to feel for them, given our own historical experience.
100%. You raise a very interesting point about hindsight is 20/20, and we mustn't be righteous about the past, because who knows, in 20 years time, 30 years time, people may look back on our society and call us immoral or unjust, and
there will doubtless be things that they look back on in our society and think, how could their eyes not have been open to these injustices and these things that were done?
Climate change, mining, climate change, treatment of animals or slaughterhouses. There are a myriad of things that people will probably look back on and say, how could we have behaved this way? And it, just saying that got me thinking that the mores, the morals of society evolve and change, and the law often has to evolve and change with it and develop. And I suppose as a common law system, a judge's job is to do that, is to change with society's changes.
The law reflects society.
Unless there's I suppose, a counter-majoritarianism argument. There was this famous case in South Africa about the death penalty, which was legal in South Africa up until about 1995. And there was a case which went to the Constitutional Court, and it was the infancy of our constitutional democracy. And the judgment of the court was by a Jewish judge called Arthur Chaskelson, and he said, "We're prepared to accept that the majority of society may want the death penalty. Let's accept that for a second. But we as judges have an obligation to protect society and to uphold the Constitution and the rights of each and individual person in society. So yes, society may want the death penalty, but we say it's incompatible with the Constitution, and they struck it out. They made the death penalty illegal. And that's a difficult balance for a judge between trying to reflect society's wants and needs and trying to protect society from itself.
Absolutely. At the end of the day, you have to apply the law, and if the law, whether the law is popular or not, and to the extent that the law is ambiguous, then one has to do one's best to effect as just an outcome as one can find. And Australia, generally in its legal culture, does not have a deep history of judicial activism. We've had periods of judicial activism, but by and large, Australian legal culture has been fairly conservative. And so those issues haven't been as politically charged, certainly not in recent years. Immigration has been one flashpoint, but by and large, we have a fairly conservative legal culture. When you get to the death penalty, of course, Jewish law has a very rich history. If you look at the Talmud, of exploring means of finding ways of exonerating or assisting the rights of accused people, particularly in relation to the death penalty. And the greatest judicial activists in some respects were the rabbis of the Talmud, because if you read the Torah, you would get the impression that people were being stoned and hanged left, right, and centre. And that's the impression you get when you watch Monty Python films, of course. But if you read the Talmud, you will see the incredibly sophisticated judicial activism to read down those fairly express commands to be sort of hanging and imposing capital punishment for every tiny infraction of law all over the place. And indeed, you get to the point in the Talmud where the imposition of the death penalty was almost impossible. So Judaism has a rich history of judicial activism to produce just outcomes.
It was something I wanted to touch on because, and where I was going is well, our secular law evolves as precedent evolves. Is halakha something that should evolve with the times, or is it something that should stay constant, and rather the application thereof to change with the times? I know that's quite a flashpoint.
Well, it is a flashpoint, and that's what I call, when my students ask me difficult questions, a 2 a.m. Shavuot night discussion. It's a tikkun leil discussion, but like any legal system, or most legal systems, there are basic or constitutional norms which are unalterable. Beyond that, things evolve. And that is equally true of the halachic process. And so there are basic fundamentals that cannot be altered. But beyond that, there are creative legal minds that permit halakha to evolve in different ways to confront new situations. I mean, one of the perhaps less appreciated but most important aspects of Jewish law, as distinct from other religious systems of religious law, in my respectful assessment, is that Jewish law is very human-centric. And so, as it were, God has conferred the power of lawmaking, of legislation, to the human mind. And the human mind's evaluation of the law prevails over that of God. And we see that, many examples of that in the Talmud. Now, that means that, and that's one of the great human features and distinct features of Jewish law that make it remarkable and unique. So it isn't the revelation of God at Sinai and smoke and lightning and then thou shalt or thou shalt not. It is a sophisticated system that is God's constitutional norms, if you like, mediated through the human intelligence and experience. the downside, if one can call it of that, is that if you have a human-centric system of law, then all human systems of law evolve or should evolve conservatively and slowly, because otherwise you get chaos. So for there to be radical transformation of the law from a religious sense, you get God appearing and God commanding and upheaval and earthquake. But that's not Judaism post-Sinai. Post-Sinai, Judaism is a human-centric system of law that evolves carefully and conservatively. And so you will, in such a system, always have tension between those who want the law to evolve more quickly and those who are more conservative. And so in flashpoint areas of Jewish law, whether it be women's rights, for example, the participation of women in Jewish ritual, and the most well-known one is the Agunah question. There are those who are very critical of the rabbis for not doing more. And there are rabbis who wish to be more conservative and slow any change right down. And that's what happens in a human-centric system of law. And that's what the greatness of Jewish law is, that it is not just the application of God's revelation. It's a human-centric application of God's wisdom. And we have to take the good with the bad, so to speak. In other words, if we're going to appreciate the greatness of such a religious system, then we have to accept that the usual tensions of conservatism and progress will manifest in disputes within Jewish law.
As it does in society as a whole.
Correct.
And
right.
we take our human experiences into our religion and our religious experiences into our humanity. And I think
but that's what Hashem wants us. The system that Hashem commanded us, if you like, is to bring our human experience and human intelligence into the development of the law. That was the process of the Sanhedrin. And with that comes human foibles.
Well, it's I see. I was told very strictly by Rabbi Marcus to please keep our talk under an hour, and I see it's getting on to 4 o'clock. The one last thing I want to ask is if you could share with us a lesson for the new year in South Africa, in Australia, in the world, and to thank you again for taking the time to speak to me.
Well, first of all, it's been a pleasure, and you and I should schmooze more often. We don't have to get onto a seminar with all sorts of other 100%. People.
I've got your number now.
No, it's been a real pleasure, and your questions have been very insightful and very provoking, interesting. At least, I don't know if everybody else who's listening is asleep, but I've enjoyed it. So,
I have to thank you very, very much, and apologies that they were provocative. It's always been a criticism of mine.
It wouldn't be Jewish if it wasn't. But
true.
And no, really. And in terms of a message, look, I think, as I've said to a number of people, Rosh Hashanah, as distinct from Pesach, is very much the Jewish people as part of humanity. Pesach is a very distinctive, particularistic Jewish expression of our faith. It's the birth of our nation, of our Jewish particularism and our birth as a nation. Rosh Hashanah is the creation of the world and the creation of humanity. And never before have we felt so much part of the burden of the whole of humanity as we have over the last year and a half. And our job as on Rosh Hashanah is really as the ambassadors of humanity in our plea to HaKadosh Baruch Hu to bring some relief to a very difficult period for the world. And we in Australia, I think, have fared better than some of the tragic circumstances that have wreaked havoc in Africa and South Africa. But nevertheless, I think we all share in each other's pain, and the stories we hear of South Africa, both in the general and the Jewish community, have been heart-wrenching. And there are so many stories across the globe of human suffering. And that's what we do on Rosh Hashanah. We say, Malach al kol ha'olam kulo b'chavodecha. We ask Hashem, the ruler of the entire world, to bring relief to humanity. And that, I think, is our role over the next few weeks. The agents and the ambassadors of humanity to seek relief for all of us, for Shana Tova, not just for the Jewish people, but for the globe, which is sorely needed for so many millions and millions of people. And that's what we pray for. And of course, it goes without saying, in Israel and the difficulties that erupt from time to time of our brothers and sisters there, but Jewish communities all over the world, and the rise in anti-Semitism. It's not a great world at the moment. And
well, if there was ever a time for Mashiach to come, it would be now.
So you said, John, that you wanted me to give a message. So as Rabbi Masinta will know, anyone who's been to the yeshivas that he and I went to, don't give a Shana Tova message without a l'chaim. And so I've prepared myself a l'chaim to you.
I would have got one.
I am very surprised.
Jonathan, quickly go get one. Jonathan, quickly go get one. It's 2 minutes of ringing.
I'll be 2 minutes. Give me a second. Never let it be said that I passed up an opportunity to have a l'chaim.
L'chaim to all your listeners, a Shana Tova to all of us, to the whole world. Shana Tova Mutuka. L'chaim. L'chaim.
Never ended a webinar. First time I've ended a webinar like that. Guys, you were great. Thank you so much.
Thank you, Rav.
Thank you, Rav.